Contracts. A survey of these questions falling under contracts would tell you that basically the problems would fall under two major topics, okay? Fundamental principles, or also known as fundamental characteristics, and defective contracts, okay? So I would also focus on these topics: fundamental principles or fundamental characteristics and defective contracts. Now, into this concept. First, are agreements contracts? Well, you must have read already that contracts are agreements, but not all agreements are contracts. How come not all agreements are contracts when agreements would involve the meeting of the minds, diba? Example, if A and B would agree that Manny Pacquiao is still the best boxer in the world despite a new classification. Ang best boxer na daw dito pound for pound is Mayweather. But if A and B had an agreement, they agreed. Is that an agreement? Yes. But is that a contract? The answer is no. Okay? Why not? Because a mere agreement will not necessarily constitute a contract. The answer here goes into the nature of a contract. What is really a contract? A contract is one of the sources of obligations. In other words, with a meeting of the minds between two persons as defined under 1305, one binds himself with respect to the other to give something or to render some service. Okay? Thus, with an agreement, for that agreement to be considered as a contract, there must be an obligation arising from that agreement. Okay? Now, in the same manner, I dare to say, dason in pago is not a contract. Okay? Dason in pago is the delivery of a thing by a debtor to his creditor in satisfaction of his debt. This is not a mere agreement to deliver. It is the delivery. Okay? Without delivery, there is no dason in pago. So dason in pago is not a contract. It is not a source of obligation. To the contrary, dason in pago is a mode of extinguishing obligations. Opposite ang kanilang nature. A contract creates obligations. Dason in pago extinguishes an obligation. Okay? But you should not confuse a contract for an obligation. An obligation is not a contract. A contract is not an obligation. Rather, a contract is one of the sources of obligations. Okay? In a way, some would be confused. There are modes of extinguishing obligations, diba? But the law would also provide for modes of extinguishing contracts. As we discussed the special contracts, example, contracts of sale, a group of modes of extinguishment will be those modes of extinguishment of obligations in general. So, if a mode of extinguishment would be a mode of extinguishing obligations, that would also be a mode of extinguishing contracts? Yes. Because if it extinguishes the contract, then the obligations arising from the contract would likewise be extinguished. Okay? Except, of course, those which have already been vested. Okay? Now, so, having discussed the nature, but I mentioned that this is just one of the sources of obligations, okay, under 1157. There are other sources, 4 other sources. In other words, given a certain scenario, for example, the case of Saludaga versus FEU, 2008 case, okay, where a student of FEU, a sophomore law student, was shot by a security guard. And, of course, he survived. He sued FEU. What possible liabilities may arise? Is it possible for a liability to arise under quasi-delict? Of course. Who may be held liable? The employer of the security guard. But can FEU be held liable under quasi-delict? The answer is no, said the Supreme Court, because FEU was not the employer of the security guard. But even if FEU cannot be held liable under that source of obligation, quasi-delict, it doesn't mean that FEU cannot be held liable at all. In fact, in this case, FEU was held liable under a contract. Because when a student enrolls in a school or university, a contract is entered into. And in that contract, one of the obligations of the school is to maintain a peaceful environment conducive to learning. This contract was violated by FEU when it relegated the evaluation of the qualifications of security guards to the security agency. Walang ginawa ang school in relation to the qualifications of the security guards. Okay? Again, given a certain scenario, it is possible that a liability may arise not necessarily from one source, but from the other sources in one given scenario. Okay? Now, is the right to enter into a contract a purely statutory right? If you remember, Dean Navarro discussed with you succession already. And authors like Justice Simpudy would take the position that the right to execute a will or to make a will is a purely statutory right. Is the right to enter into a contract similar, the same, in the sense that it is a purely statutory right? I don't think so. This right is protected under the Constitution, okay? There is a clause in the Constitution known as the non-impairment clause, okay? Not even the state can violate the rights of the parties to a contract, okay? With exception, of course, if it is in the exercise of police power, okay? Now, then, one last. Is marriage a contract? As a contract is defined under 1305. Obviously, it is not, okay? In fact, the Family Code would consider it as a special contract. Why so special? Well, there are differences, okay, between this contract and contracts under the Civil Code. Example, who may be the parties to this contract? Under the Family Code, as to marriage, the parties can only be a male and a female. Well, in contracts, it doesn't matter. Male with male, female with female, it doesn't matter. Now, the governing law, what primarily would govern the rights and obligations of the parties to a contract? The answer is the stipulations, okay? The terms and conditions agreed upon by the parties that would primarily govern. Of course, subject to the limitation that they are not contrary to law, morals, etc. Diba? But as far as marriage is concerned, of course, primarily the rights and obligations of the spouses shall be governed by law, not by their stipulation. Okay? Except yung property relations nila. To the contrary, opposite. Okay? Finally, of course, termination. Nako, there are so many modes of termination or extinguishment of contracts, okay? But marriage ordinarily would be extinguished only by the death of one of the parties, till death do us part, diba? Except, of course, if there is annulment. Even declaration of nullity is not extinguishment or termination, because in the first place, the marriage did not exist. It's just a mere declaration of the nullity of the marriage, okay? Now, into this definition. In every concept, I always would recommend that a student or a reviewee examinee should try to memorize at least the definition of the concept, okay? I have not ever demanded from a student that he memorize all the provisions sa Civil Code of the Philippines, but at least the definition. From the definition, you may be able to answer some questions because these definitions would actually capsulize the essence of the concept, diba? Pinaghirapan nila ang mga definition na ito. But there are also defects, allegedly. Okay? Some of these definitions are defective. Example, as to contracts, the law defines a contract is a meeting of the minds between two persons. In other words, there should be two persons in order for a contract to be perfected. But the question here is, may a person contract with himself? In other words, may there be rights and obligations arising from a contract even if only one person participated in the execution of the contract? The answer is yes. This contract is known as an auto contract, okay? A person may contract with himself in one capacity representing another person, and in another capacity for himself, acting for himself, or even acting for another person. A good example of an auto contract is when a person is authorized to borrow money. If he is authorized to borrow money, can he himself be the lender? Under the law, yes. The only limitation provided by law is that the interest must be the market rate. In other words, in that loan agreement, he will be signing as representative of the principal, of the borrower, but he will also be signing as for himself, as the lender, okay? This is an auto contract, and this is a valid contract. This may be a valid contract. Of course, there are auto contracts which are prohibited under Philippine law by way of exception. One such contract will be discussed in detail under the law on sales. Under 1491, a guardian is prohibited from acquiring by purchase the property of his ward. In other words, in a deed of sale, the guardian cannot be the seller at the same time he is the buyer. Okay? Now, thus, it is said that despite the use of the word persons in the definition between two persons, the Code Commission really contemplated parties. Okay? So, between two parties. Now, if you will again consider this definition closely, it is thereafter provided that whereby one binds himself with respect to the other. Does it mean therefore that only one of the parties would be obligated in a contract? Only one of them would bind himself to the other. In other words, all contracts are unilateral contracts? Of course not. Of course, this is considered as a defect in this definition because I would even say ordinarily, reciprocal obligations would arise from a contract. In other words, contracts ordinarily would be bilateral in character. Both parties would be obligated. Of course, there are contracts which are unilateral, okay? We will discuss these kinds of contracts as we discuss the classification of contracts. But finally, may an obligation not to do arise from a contract? If you will read the definition again, it says the last phrase, to give something or to do some service. So apparently only obligations to give and to do may arise from a contract. But then again, it's not really accurate because even obligations not to do may arise from a contract. All of us must have observed already that there is not a single taxi cab na Honda, di ba? Have you noticed a taxi cab na Honda ang tatak? It is because in each and every contract of sale entered into by the dealers of Honda, there would be a stipulation that the buyer cannot use the car as a taxi cab. So that is an obligation not to do. Okay? On the other hand, we must have noticed some stores. In some stores, mga sari-sari store, they would only sell certain products. Di ba? Yung iba, lahat Coca-Cola products. Yung iba, Pepsi-Cola products. It is because in these contracts, again, there would be a stipulation that they cannot sell the products of other brands. Di ba? Kaya even from these contracts, obligations not to do may arise from a contract. Now, I can proceed to the fundamental characteristics. Okay? Precisely because they are fundamental, kaya maraming tanong dito. Authors would enumerate the fundamental characteristics into 5. Okay? First, autonomy of contracts, then consensuality of contracts, then mutuality, obligatory force, others would call obligatoriness, and finally, relativity of contracts. Okay? Now, what is this autonomy of contracts? Okay? Under 1306, the contracting parties may establish such stipulations, clauses, terms, and conditions as they may deem convenient. Okay? Kaya siya autonomy because they can validly stipulate as they may deem convenient. Others would call this as liberty of contract or freedom of contract. Okay? Example, the parties in a contract of loan of money agreed that the yearly interest rate is 12%, can be increased if there is a law that would authorize the increase of interest rates. Suppose OB, the lender, would increase by 5% the rate of interest to be paid by TY, the borrower, without a law authorizing such increase. Would OB's action be just and valid? Why? Has TY a remedy against the imposition of the rate increase? The question was, would OB's action be just and valid? The answer is definitely no, okay? Again, under the autonomy of contracts principle, the parties can establish such stipulations, terms, and clauses as they may deem convenient. They agreed that there can only be an increase if there is a law. And since there was no law, there can be no valid increase, okay? But in one case, if you have read this case, the parties agreed, similar to the stipulation, that there should be a law which authorizes the increase of interest rate. Thereafter, at that time, the usury law had not yet been suspended. The central bank at that time issued a monetary board resolution allowing the increase in the interest rate. Now, with that monetary board resolution allowing the increase in the rate, would that now give the lender the right to increase the interest rate, considering their stipulation? The Supreme Court still said no, because a law is not the same as a monetary board resolution. And a monetary board resolution may have the force of a law, but it is not a law. And therefore, since the parties agreed that only if there is a law would there be an increase, since there was no law, merely a monetary board resolution, there can be no valid increase in the interest rate. Okay? Kaya lang, example, in a contract of partnership, entered into by A, B, and C. And in that contract, it was stipulated that out of the profits of the partnership, 50% will go to A, the other 50% will be given to B. Thus, if 100,000 profit was earned by the business of the partnership, who will share this profit? Would A and B share 50,000 each? The answer is definitely no, because this stipulation as to the sharing of profits is void under the law. In other words, while the parties can establish such stipulations, clauses, terms, and conditions as they may deem convenient, the requirement of the law is that these stipulations should not be contrary to law, morals, good customs, public order, or public policy. Okay? As to laws, whether a stipulation is contrary to law or not, wala tayong magagawa. We just have to know the law. Okay? The laws, which declares certain stipulations to be void. Example, a forfeiture clause. May a forfeiture clause in a contract be void? Is there a law which provides for the nullity of a forfeiture clause? There is, okay? And that would be applicable if you are confronted with the Maceda law. If the problems would pertain to or covered by the Maceda law, that law declares such clause to be a void clause. But in other instances, mukhang valid siya. Diba? Forfeiture clause. Waivers. Of course, ordinarily, a waiver may be a valid waiver. Diba? If all the requisites are present. But are there laws which consider some waivers void? Of course, there are many laws. Okay? Example, Don, an American businessman, secured parental consent for the employment of 5 minors to play certain roles in 2 movies he was producing at home in Makati. They worked at odd hours of the day and night, but always accompanied by parents or other adults. The producer paid the children talent fees at rates better than adult wages, but a social worker, DEB, reported to SWF that these children often missed going to school. They sometimes drank wine, aside from being exposed to drugs. Okay? In some cases, they were filmed naked or in revealing costumes. In his defense, Don contended, all these were part of artistic freedom and cultural creativity. None of the parents complained, said Don. He also said that they signed a contract containing a waiver of the right to file any complaint in any office or tribunal concerning the working conditions of their children acting in the movies. Is the waiver valid and binding? Why or why not? Here, the waiver is a void waiver because this would obviously be contrary to the law which provides for protection of minors, okay? The employment of minors under our labor law. Thus, any waiver in relation to this rights of minors of the law protecting the rights of minors would be a void waiver as it is contrary to law, okay? In sales, if there is a waiver as against the seller in case of eviction, that would be a void waiver if the seller was in bad faith. Diba? Waiver as to future fraud, you must have discussed already in obligations, is a void waiver. Okay? Now, other stipulations like ang mga pactum. Basta lahat ng pactum mukhang void. Okay? Pactum commissorium, pactum leonina, pactum non aliendo, they are void stipulations. Of course, Pactum leonina, this is the stipulation I mentioned a while ago. A stipulation in a contract of partnership which excludes at least one of the parties from sharing in the profits is a void stipulation. That's Pactum leonina. Pactum commissorium is a stipulation in a contract of pledge or mortgage which provides that upon default of the principal debtor, the property pledge or mortgage will automatically be owned by the pledgee or mortgagee. Okay? And the pactum non aliendo in real estate mortgage is a stipulation prohibiting the mortgagor from alienating his property without the consent of the mortgagee. That is a void stipulation. Okay? But there are other stipulations which may or may not valid depending on the circumstances. Example, this one. July 1, 1998, Brian leased an office space in a building for a period of 5 years at a rental rate of 1,000 a month. The contract of lease contained the proviso that in case of inflation or devaluation of the Philippine peso, the monthly rental will automatically be increased or decreased depending on the devaluation or inflation of the peso to the dollar. Okay? Starting March 1, 2001, the lessor increased the rental to 2,000 a month on the ground of inflation proven by the fact that the exchange rate of the Philippine peso to the dollar had increased from 25 pesos to a dollar to 50 pesos to a dollar. Brian refused to pay the increased rate and an action for unlawful detainer was filed against him. Will the action prosper? Why? Again, in answering questions, if you are confronted with a problem involving a contract of lease, for example, as in this case, does it mean that the answer to the question would be a provision under the law on lease? Not necessarily. Okay? In other words, lease contract ang nakalagay pero actually ang sagot nasa oblicon. Di ba? Thus, you just have to know the issue really in the problem. Hindi mo kailangang malaman ang mga provisions sa lease kasi wala doon ang sagot. Okay? But, will the action prosper? If you read the suggested answer of the UP Law Center to this question, the answer was no, the action cannot prosper because there was no extraordinary inflation. In fact, another alternative answer, which would also give you a no as an answer, is because in order for 1250, apparently the applicable provision is 1250, to be applicable, there has to be an extraordinary inflation or deflation which is declared by the Bangko Sentral ng Pilipinas. There being no declaration of such extraordinary inflation, there can be no adjustment as to the compensation. With all due respect to those answers, I think those answers are wrong. Okay? I believe the alternative answer, the last alternative answer is the best answer. Okay? Because nothing in the problem would tell you that the parties required extraordinary inflation. Tingnan nyo ang facts, nakalagay lang was inflation or devaluation. Hindi naman nila ni-require na extraordinary. So, we just go by the stipulation of the parties. It is the stipulations, clauses, and conditions agreed upon by the parties which will bind the parties. Okay? And Why I am so sure of my position? Because this is similar to a case decided by the Supreme Court. This is similar to the case of Del Rosario versus Shell, where in fact the Supreme Court recognized the validity of the stipulation in relation to the rentals where Shell was the lessee. Ganun din, similar ang stipulation. If there would be a devaluation, then there would be an increase in the rental. Is that a reasonable reason for the increase in the rental? Of course. Kasi kung nag-devalue ng ang peso, ikaw ang lessor, wala nang silbi ang rental sa'yo. Diba? In this case, 100% ang devaluation, then the rental should likewise be increased 100%. That is only a reasonable stipulation. Now, the problem clearly pertains to a clause known as an escalation clause. Take note, do not confuse this clause from an acceleration clause. Okay, this is an escalation clause. In this clause, upon the happening of a certain contingency, the compensation of one of the parties may be increased. Okay, so this would normally happen in loans. In loans, depending on the happening of a certain contingency, like if the market rate of interest would increase, then the bank may increase the rate of interest. Okay. However, here in lease contracts, it will be the rental which will increase. If you will be a counsel of realty firms, you would notice if you are on the side of the contractor, you should always ensure that there is such an escalation clause in favor of the contractor. Okay? So, for example, a common escalation clause would be that for every 1 peso increase in the minimum wage of a worker in Metro Manila, there would be a corresponding 10 million increase in the compensation of the contractor. That is a reasonable stipulation because pag nag-increase ng piso ang minimum wage and you have 2,000 workers, ay talo ka, ubos ang kita mo, baga lugi ka pa if you are the contractor, if there will be no escalation as far as the compensation of the contractor. Okay? But may an escalation clause be considered void or ineffective? Or may an escalation clause not be given effect? The answer is yes. If this escalation clause is an escalation clause in a contract of loan, which would give the bank, for example, the right to increase the interest, because one of the reasons why this clause would be void is because there is no de-escalation clause. It is because there is a monetary board resolution as far as loans are concerned that for an escalation clause to be valid, there should be a de-escalation clause. Okay? The evil here which is to be prevented is the practice before that if the interest market rate would increase, the bank would increase the rate. But if the market rate would decrease, the bank will not decrease the interest rate. Diba? So there is that requirement. Okay? Of course, a limitation also as far as this clause is concerned is the bank cannot increase the rate more than once in a year. Okay? Once a year lang. Unlike in one case, 4 times a year in-invoke niya ang escalation clause. That is not possible again considering the monetary board resolution on the matter. Okay? Important requirement for an escalation clause is that it should not be solely potestative in character. In other words, whether or not the clause would be applicable should not depend on the whim of only one of the parties. The Supreme Court would say it should be based on a reasonable and valid standards. Okay? Basta ganon, pwede na. It may be a valid escalation clause. So, escalation clause. Okay? Now, in this case, you must have heard of a non-involvement clause in a contract of employment or employment contracts. Okay? In a case decided in 2007, Daisy 2 versus Platinum Plans, ito ang stipulation, non-involvement provision, that the employee further undertakes that during his or her engagement with the employer and in case of separation from the company, whether voluntary or for cause, he/she shall not for the next 2 years thereafter engage in or be involved with any corporation, association, or entity, whether directly or indirectly, engage in the same business or belonging to the same pre-need industry as the employer. Any breach of the foregoing provision shall render the employee liable to the employer in the amount of 100,000 pesos for and as liquidated damages. Okay? Is this a valid provision? Is this a valid clause? Non-involvement clause. Okay? In one case, the Supreme Court ruled that this is not a valid clause because that would limit the right of a person as far as his livelihood is concerned. This would be an unreasonable restraint of trade in that case. Okay? However, in this particular case, was the provision considered as a void provision, as an unreasonable restraint of trade? The Supreme Court said no in this particular case. Daisy Chu obviously resigned from Platinum Plans and joined another pre-need company, Professional Plans yata of the Philippines. Okay? The reason given by the Supreme Court why this stipulation, this clause is not a void clause, because this is not an absolute prohibition. Okay? There are limitations to the prohibition in relation to the period, in relation to the trade, in relation to the area. Okay? Mukha namang hindi naman until she dies. Ang nakalagay lang naman ay 2 years. At hindi naman she cannot join any corporation. She just cannot join another corporation engaged in the same business, pre-need business. Okay? Plus, of course, apparently this limitation pertains only to the Philippines. Okay? Now, this the Supreme Court ruled is a reasonable protection to the rights of the employer, especially because this defendant, Daisy Chu, who is the petitioner in this case, was actually the Assistant Vice President of Platinum Plans in charge for the ASEAN region. Her position in the company is so important that she would know the strategies of the company. So to protect the employer, this provision was considered as a reasonable limitation on the rights of the employee. So, non-involvement clause. Okay? Now, contrary to law. Okay? How about contrary to morals? Well, of course, the Supreme Court would tell us that whether a stipulation is contrary to morals or not is the most difficult task to do. Okay? The most difficult to ascertain is whether a stipulation is contrary to morals. Because obviously, what is moral to one may not be moral to the others. If I ask you the use of contraceptives, would that be moral or immoral? Mga ganyan. So would the sale of contraceptives be immoral or not? Okay? Of course, others would claim that is immoral. Although almost everyone is using contraceptives. But ordinarily, what stipulation would be considered immoral by the Supreme Court? Ang pinakamadaming kaso would pertain to interest stipulation. Example, or penalties. For example, if the penalty is 5 pesos a day for every day of delay, would that be contrary to morals? Would that be excessive, iniquitous, unconscionable? 5 pesos per day? Of course, ang sagot, it depends on the principal amount. Kasi kung ang principal amount, 10 million pesos, what is 5 pesos a day? Pero in one case where the principal amount was only 465 pesos, and the penalty is 5 pesos per day, aba, sabi ng Supreme Court, this stipulation is immoral. Okay? Contrary to morals, unconscionable, excessive, because 5 pesos per day, 465, almost 400% per annum na ang penalty. Yeah? Now, into interest stipulations, if you have read cases like Solongon versus Solongon, yung mga 5.5% interest per month or 6% per month would obviously be considered contrary to morals, excessive, iniquitous, unconscionable, di ba? Pero, that would be because 6 times 12, that's 72% per annum, di ba? But, would 3% per month also be unconscionable, immoral, or contrary to morals? The Supreme Court ruled in a recent case, the case of Macalinaw versus BPI. And in this case, decided on September 17, 2009, an agreement involving a credit card, obviously involving BPI, which provides for an interest na 3% per month plus penalty in case there is failure to pay on the date agreed upon. 3% per month din ang penalty. Effectively, that would be 36% per annum only. But the Supreme Court in this case ruled that this interest stipulation and the penal clause, they are both void. Okay? They are unconscionable, they are iniquitous, they are contrary to morals, if not against the law. Okay? 3% lang, samantalang yung iba, 10% per month. Diba? There are cases na 10% per month. Ito 3%. Of course, the Bankers Association of the Philippines would claim that this ruling is applicable only to this case because really this will have a grave effect as far as banks are concerned. What is the effect pag void ang interest stipulation? Does it mean that the lender can no longer recover interest? Hindi naman. Okay? The Supreme Court in this case, consistent with the other decisions, only reduced the interest to 1% per month. Pati na rin ang penalty, nireduce na rin sa 1% per month. Effectively, that's 12% per annum, which is the legal rate as far as loans are concerned. So the lender can still recover interest, pero legal rate na lang, 12% per annum. Kaya kung may mga hindi kayo nabayaran sa bangko na mga dahil sa credit cards, you might want to invoke this ruling in Macalinaw versus BPI, which the Bankers Association of the Philippines is claiming to be applicable only to that case. Of course, if you read the case, there appears to be no basis to that claim. Basta any agreement involving credit cards, this may be invoked. Okay? Now, contrary to morals, of course, a stipulation or a provision in a contract may be contrary to public policy and therefore, again, void. The first question here is, how would you know if there is a public policy involved in relation to a certain topic, a certain subject matter? And where will you find this public policy? Saan nyo ito makikita? Ordinarily, if a law is passed, there would normally be a public policy behind the law that will be cited by the lawmakers, di ba? Although sometimes wala, di ba? They will not at all even mention a public policy. But where will you find public policies in this country? Siyempre nandun sa fundamental law of the land, nasa Constitution, okay? While I have not asked anyone to memorize the Civil Code of the Philippines, I have asked my students, reviewees, examinees to try to memorize the Constitution. Okay? You will not only be benefited by that sa political law, pati sa labor law, pati sa civil law, pati remedial law, criminal law, magagamit nyo ang Constitution. In fact, last year, ang mga tanong sa labor law, enumerate constitutional provisions protecting labor. Di ba? Mga ganon. So, ganon ka objective. Ganon din sa civil law. As we discuss certain topics sa contracts or sa sales, the answer may be under sa Constitution. Okay? Concretely, itong bar exam question na ito. Alma was hired as a domestic helper in Hong Kong by the Dragon Services Limited through its local agent. She executed a standard employment contract designed by the Philippine Overseas Workers Administration for overseas Filipino workers. It provided for employment for 1 year at a salary of $1,000 a month. It was submitted to and approved by the POA. However, when she arrived in Hong Kong, she was asked to sign another contract by Dragon Services Limited, which reduced her salary to only $600 US dollars a month. Having no other choice, Alma signed the contract, but when she returned to the Philippines, she demanded payment of the salary differential of $400 US dollars a month. Both Dragon Services Limited and its local agent claimed that the second contract is valid under the laws of Hong Kong and therefore binding on Alma. Is their claim correct? Explain, okay? Of course, even if the examiner would not ask you to explain, always explain. Hindi pwede ang yes or no lang. Ang mas importante ay ang explanation. Now, is their claim correct? I would agree that the claim is not correct because even if that contract, even if the stipulation in that contract where the salary would only be $600 US dollars a month is a valid stipulation and that contract is a valid contract under the law of Hong Kong, it cannot be enforced in this jurisdiction because that contract, specifically that stipulation, is contrary to our public policy. And the public policy is in the Constitution, which provides full protection to labor. Okay? So if only for that, claim of Dragon Services is not correct. Okay? Now, public policy. In certain cases, the Supreme Court would declare null and void a stipulation. For example, in the case of Cui versus Arellano School of Law, where Cui was a student and he enjoyed a scholarship as a student of Arellano. However, it was stipulated in that scholarship program that if he would transfer to another law school, he will have to reimburse Arellano for the amounts which he should have paid had he not been a scholar. Okay? The law dean of Arellano at that time was the uncle of Cui. And when the law dean transferred to another law school, Cui also transferred together with his uncle. There was no problem at that time until he was about to take the bar exam, because then he would need the grades from Arellano. But Arellano refused to release the grades until he would reimburse Arellano as so provided in the scholarship agreement. Walang magawa ang Cui, he paid under protest for him to be able to take the bar exam. Obviously, he passed the bar exam and sued Arellano. And sabi ng Supreme Court, that stipulation is void. Why is it void? Because it is contrary to public policy. What is the public policy involved in this case? Scholarship grants are granted on the basis of merit, and it should not be granted in order to bolster the reputation of law schools, of any school. So that if a student would want to transfer to another law school, he should not be required to reimburse whatever amount he should have paid had he not been a scholar. Okay? Kaya today, if you have noticed sa mga eskwelahan, iba ang scholarship, iba ang grants. Merong scholarship based on merit kasi valedictorian ka, kasi salutatorian ka, or nasa OPF ka, kumbaga, Order of the Purple Feather. But iba ang grants because there could be conditions in these grants, okay? That you have to teach, you have to work in the Philippines, etc. Now, in another case, which is relevant these days, involving an agreement of two persons vying for the official nomination as a candidate of a party, I think it's Nationalista Party, as the official candidate for a congressional seat in Pangasinan, mga 5th district yata sa Pangasinan. It was stipulated in their agreement that they would have to go through the process ng convention, and whoever would lose in that convention shall not run as an independent nor a rebel candidate. Okay? Obviously, itong Sindico, the defendant, lost in the convention, in the party convention, but she still ran. Okay? At mukhang nanalo siya. So, Saura sued Sindico for damages. Did the action prosper? The Supreme Court again said, the action cannot prosper because that stipulation which prohibited Sindico from running as an independent is a void stipulation because it is contrary to public policy again. What is the public policy involved? In this case, the Supreme Court discussed two public policies. That a mere agreement of two persons cannot limit the right of a person to present himself as a candidate in an electoral contest. But the other public policy discussed was an agreement between two persons cannot limit the right of the electorate to choose who among the candidates is fit for that particular position. This case was decided decades ago, and I dare to say that the first discussed public policy is no longer a public policy today under our present constitution. It is no longer considered a right for a person to present himself as a candidate. Rather, this is merely considered now as a privilege. But the other public policy discussed is definitely a good public policy, that a mere agreement of two or more persons cannot limit the right of the electorate to choose who among the candidates is fit for that position. Take note that even public policy can change. Hindi lang morals ang nagbabago, hindi lang batas ang nagbabago. Maski public policy may change, although not as fast as certain laws, especially siguro sa labor law. Sa civil law, hindi masyado. Medyo stable ang civil law. So, public policy. Now, into another fundamental principle known as consensuality of contracts. Okay? Under this principle, for a contract to be valid, the parties must voluntarily give their consent. In other words, no one can be compelled to enter into a contract. If he was compelled, if you read this case, there is one other way of answering this question. That other contract signed in Hong Kong may at least be considered as avoidable contract under Philippine law because of the statement having no other choice. It appears that there was vitiation of consent, diba? So you can attack the problem in that perspective, okay? Kung gusto mo, dalawa ang sagot mo, diba? Sigurista. Para talagang kumbinsido ang examiner, okay? But under the consensuality of contracts, again, no one can be compelled, not even the government, not even City Hall, can compel anyone to enter into a contract. Unbelievably, in the case of Republic versus PLDT, the government filed an action to compel PLDT to enter into an interconnection agreement. At that time, when the action was filed, yung telecommunication services within the country was controlled by PLDT. And as far as the telecommunication industry with other countries, controlled din by PLDT except to the US. Sa US may mga kakompetensya siya. And the government would want to have use of this interconnection services ng PLDT. Kaya lang mukhang ayaw ng PLDT ng terms and conditions. It doesn't want to enter into that contract. So the government filed this action. Obviously, the Supreme Court said PLDT cannot be compelled to enter into a contract. Consent must be voluntarily given in order for a contract to be a valid contract. There should be a meeting of the minds. Consent must be freely given. Okay? Although if you have read this case, may lusot ang Supreme Court. This action was treated as an expropriation proceeding. So walang lusot ang PLDT. Although this appears to be improper kasi may procedure dapat to be followed in expropriation of properties. Now, in relation to this fundamental characteristic, consensuality of contracts, there is a contract which is claimed to be void, allegedly for lack of consent of one of the parties, because the contract was prepared by only one of the parties. Okay? The terms of conditions have already been prepared by a party considered as the stronger party. And such contract is presented to the other party for his adhesion, for him to sign the contract. In other words, there was practically no negotiation as to the terms and conditions. There was no consent as to the terms and conditions. And this contract is obviously known as a contract of adhesion. lahat tayo pumasok na sa kontratang ito. I'm sure sumakay na kayo ng eroplano or maski bus. O kaya you send items or letters through JRS or LBC. Ang mga contracts na ito ay contracts of adhesion. Kung ayaw mo ng terms and conditions nila, sa iba ka na lang pumunta. Di ba? Kung ayaw mo ng terms and conditions ng Philippine Airlines, sumakay ka sa, dati ang pangalan ay Asian Spirit, di ba? Yung tipong you fly as an Asian, you land as a Spirit, di ba? Pero ngayon, iba na ang pangalan niya. Medyo alive, Zest, di ba? Zest Air, yun ang pangalan niya. In fact, in one case, if you read this case of Ong Yu versus Court of Appeals, Attorney Ong Yu was on his way to Butuan City, if I remember it right, a city in Mindanao. And his luggage was lost, nawala. And he filed an action against Philippine Airlines claiming damages as a result of the loss of the damage. Kaya lang, PAL invoked a provision in the contract that if at all PAL can be held liable for the loss of luggage, that cannot exceed 100 pesos. Of course, the claim of Attorney Ong Yu was this is a contract of adhesion and this is a void contract because practically he did not give consent to the contract. Sabi ng Supreme Court, of course not. A contract of adhesion, as a rule, is a valid contract because after all, the other party has a choice whether to accept or to reject the contract. If he bought the ticket, he practically accepted the terms and conditions. At that time, it was really difficult for people like Ong Yu not to accept because the consequence before, if you remember lalo na nung 60s, even 70s, there was only one domestic commercial airline company dito sa Pilipinas, Philippine Airlines. Wala pa namang Cebu Pacific, etc. In other words, if you don't agree with the terms and conditions of PAL, gusto mong pumunta ng Davao, ang alternative mo ay lumangoy papuntang Davao, di ba? Or you can ride a ship of Sulpicio Lines. Mga tipong Princess of Stars ang sasakyan mo. Pero ngayon, this ruling is much more acceptable because you really have a choice. Okay? Aside from Asian Spirit, mayroong Air Philippines, mayroong Cebu Pacific, etc. However, in relation to this contract, in this case, Metrobank versus Jimmy Go, 2007 case involving a trust receipt, which is obviously a contract of adhesion. Of course, Jimmy Go claimed the issue was one of the issues, whether or not the trust receipts are valid, considering that they are contracts of adhesion. But the Supreme Court said again, these contracts are valid. However, in these contracts, if there is ambiguity in the contract, such ambiguity shall be construed against the party who prepared the contract. Okay? Since it was Metrobank who prepared the contract, the ambiguity was decided by the Supreme Court against Metrobank, against the interest of Metrobank. Practically, the second issue here goes into the question as to when did the obligation of Jimmy Go to deliver the goods arose, considering that this contract is a contract of adhesion and there was ambiguity as to when the goods have to be delivered. Sabi ng Supreme Court, this stipulation should be construed against Metrobank, and it was ruled that the obligation became due only when demand was made by Metrobank. Okay? So, consensuality of contracts. Into another fundamental characteristic. Okay? This scenario. We will be discussing in detail this stipulation, a contract known as stipulation por attrui. Okay? A stipulation, a contract for the benefit of a third person. Now, in order for the beneficiary to be entitled to this benefit, one of the requirements under the law is that he must communicate his acceptance to the obligor before the revocation of such benefit. A question here is, what if one of the parties to the contract, di yung beneficiary, okay, revoke the benefit? In fact, he may have sent a letter to the beneficiary informing the beneficiary that the benefit in your favor in the contract which I entered into with B had already been revoked. And he sent this letter, revocatory letter, before the beneficiary could communicate his acceptance. Does it mean that the beneficiary would no longer be entitled to this benefit? The answer is not necessarily. He may still be entitled because in order for the revocation to be effective, it has to be consented to by both parties. Otherwise, if only one of the parties would revoke the benefit in favor of this beneficiary, that would be contrary to a fundamental principle in contracts known as the Mutuality of Contracts principle. Okay? Under this principle, a contract must bind both contracting parties, and its validity or compliance cannot be left to the will of one of them. So, as far as the benefit is concerned, as it was agreed upon by both parties, that can only be revoked by both parties. Again, a revocation by only one would be contrary to this fundamental principle known as mutuality of contracts. Okay? Now, a while ago we discussed a clause known as escalation clause. If an escalation clause would be invoked by a party at his whim without any reasonable and valid standard, the Supreme Court would rule that that is contrary to the Mutuality of Contracts principle. Thus, again, for that clause to be given effect, it should be based on a valid and reasonable standard. It should not be solely potestative in character. Okay? But in relation to this fundamental principle, would the termination of a contract by one of the parties be violative of this fundamental principle? If one of the parties in a contract is given the right to terminate the contract by his own will, by his unilateral act, would that be contrary to the Mutuality of Contracts principle? The Supreme Court said no. Okay? Example, in the case of Phil Banking versus Louis Xi, involving a contract of lease where the lessee was given the right to terminate the contract by merely giving notice to the lessor, and the termination would take effect like within 15 days from receipt of the notice of termination. The Supreme Court said that does not violate the Mutuality of Contracts principle. That is not covered by the Mutuality of Contracts. What is covered pertains to the validity or compliance. It does not pertain to the termination of the contract. Okay? Then, one other. Obligatory force, or others would call again obligatoriness of contracts. Under this principle, obligations arising from contracts have the force of law between the contracting parties. This is not a law, but this has a force of law between the contracting parties and should therefore be complied with in good faith. Okay? Probably the first question here is, when would a contract have the force of law between the contracting parties? The fact that there was already a meeting of the minds as to the object or subject matter and the cause, does it mean that the contract already has the force of law? Not necessarily. In order for a contract to have the force of law, the contract must have been perfected. It is at the time of the perfection of the contract that either party to the contract can compel the other party to perform his obligations under that contract. Of course, just because a contract had been perfected, does it mean that the contract is enforceable? Not necessarily, again, because the perfection of a contract is also subject, for example, to the statute of frauds. A contract of sale may have been perfected because there was already a meeting of the minds as to the object and the price. However, if it is not in the form prescribed by law and it is covered by 1403, that would be an unenforceable contract. We will discuss these kinds of contracts as we discuss the classification of contracts. For now, again, a contract generally would have the force of law between the parties upon the perfection of such contract. Now, another fundamental principle, the last one, relativity of contracts. The question here is in contracts. Example, A sold an item to B. Thereafter, B sold the same item to C. Ordinarily, would A have a cause of action against C? The answer ordinarily would be none, because there is no privity of contracts between A and C. Si A and B ang dito sa contract, and B and C as to the other contract. So who would be bound to a contract? Ordinarily, it would be the parties, or who would be affected, who would be benefited, who can be held liable. The rule, only the parties, hindi naman. The rule would be the parties, their assigns, and heirs would be bound to a contract, would be affected by a contract. Parties, assigns, and heirs. The assigns and heirs are called privies to that contract. Kaya ang principle na ito is known as the Privity of Contracts principle. So, under 1311, contracts take effect between the parties, assigns, and heirs. However, is it possible for a contract not to affect the heirs, not to benefit the heirs? The answer is yes. Under this provision, a contract may take effect only between the parties if the rights and obligations arising from this contract are intransmissible. When would these rights and obligations be intransmissible? There are three scenarios. Okay? When the law so provides, if there is a stipulation, and of course, if the nature of the rights and obligations would not allow the transmissibility of these rights and obligations. Okay? Stipulation probably is the easiest. Example, in a lease contract decided by the Supreme Court, which was the subject matter of a decision of the court, there was a stipulation in the contract that the rights and obligations arising from their contract are intransmissible. Ganon ka literal ang stipulation. Now the lessee died. Would his heirs still have the right to the possession of the leased premises until the expiration of the period? Clearly, the Supreme Court said no, because with the death of the lessee, the contract was extinguished, because the rights and obligations arising from the contract are intransmissible by stipulation. Ordinarily, would the heirs of a lessee still have the right to continue to possess? The answer is yes, because the Supreme Court would rule that a lease contract is not a purely personal contract, and therefore the rights and the obligations arising from that contract may be transmitted to the heirs, to assigns. Even in lease contracts also, can a lessee ordinarily sublease the premises in whole or in part? The answer is yes, except if he is prohibited from subleasing the property. So again, by stipulation. But law, is there a law which provides for the intransmissibility of certain rights? Yes. Under the law on usufruct, ordinarily, when a usufructuary dies, would his rights be transmitted to his heirs? The answer is no, because the law so provides. But there's an exception to this, if there is a contrary stipulation in the contract, in the agreement. Okay? Now, as to non-transmissibility or intransmissibility by contract or by agreement, a good example here would pertain to a property right of a partner known as the right in specific partnership property. By express provision of the law, a partner cannot assign his right in a specific partnership property without all the other partners making the same assignment over the same property. Kaya, a partner alone without the knowledge of the other partners cannot transmit his rights to an assignee by law. Okay? Nature, it goes into the, again, nature of the rights and obligations. The Supreme Court would say if the rights and obligations are purely personal, or the qualifications of the parties have been considered in the establishment of the contract. This is common, of course, in contracts which would involve skills. Maybe a good example would be a contract with Regine Velasquez as the artist who would sing in a concert. Of course, with the nature of such rights of Regine, she cannot transmit or assign such rights to Judy Ann Santos because of the nature of the right, which is a purely personal right. Okay? Then, however, in relation to this principle, privity of contracts, while generally only the parties, the assigns and heirs, would be bound to be affected, but under certain circumstances, a third person may be bound to a contract. A third person may be held liable under a contract in which he is not a party, in which he is not even privy. Or a person may have a cause of action. Ordinarily, a third person would not have a cause of action in relation to a contract. He would not have the right to rescind a contract which he is not a party, or he is not privy. Or he may be benefited, or he may be prejudiced by such contract. And this time, this one pertains to the relativity in general, relativity of contracts. Okay? The first of these scenarios where a third person, let's start with a third person may be bound to a contract. This would involve contracts involving or creating real rights. Okay? In contracts creating real rights, third persons who would take possession of the object or subject matter of the contract would be bound to such contract. Subject, of course, to the requirements, sabi ng batas, sa mortgage law, registration laws, etc. Probably the best example of this would involve a real estate mortgage involving a parcel of land entered into probably between A and B, B being the mortgagee, A would be the mortgager. If A sells this land to C, and thereafter, if A, the mortgager, is also the principal debtor, he defaulted, can the mortgagee foreclose this mortgage over this parcel of land? If the sale and the land may have been delivered to C, C would already be the owner of the land. But may there still be a valid foreclosure over the land even if the land is no longer owned by the mortgagor? The answer is yes. It is possible because, again, in such contract, which creates real rights, the rights of the mortgagee attaches to the property. Whoever may be the owner of the property will be bound to this mortgage. Maski siya na ang may-ari, his ownership will be subject to the rights of the mortgagee. Again, subject to the qualification of the law. Ang qualification ng batas, subject to the law on mortgage, registration laws, because for C to be bound to this contract, C is not a party to this contract, C is not even privy to this contract. Nonetheless, he would be bound if this contract is registered. Or at least, even if not registered, if C has actual knowledge of this contract, because as the Supreme Court would say, actual knowledge has the same effect as registration. So again, C, a third person, is not a party to the mortgage, is not privy to the mortgage, but he will be bound to this mortgage because a mortgage creates real rights. Okay? Pangalawa would involve contracts in fraud of creditors. Here, an example would be, itong si A sold a parcel of land to B, but the sale was in fraud of a creditor like X para walang mahabol ang creditor niya. So, binenta ang kanyang properties. Now, ordinarily, X, being a third person, would not be bound, would not have a right in relation to this contract, would not have a cause of action in relation to this contract. But because this contract is in fraud of a creditor, the law grants him the right to rescind. If you remember, this is one contract considered as a rescissible contract under 1381. So, contracts in fraud of creditors, we will discuss in detail when we discuss rescissible contracts. Pangatlo would be a scenario where a person ordinarily who is not a party to a contract or not privy to a contract cannot be held liable under such contract. Anong pakialam ko sa inyo dyan, di ba? Hindi naman ako party sa contract na yan. Hindi naman ako privy. Why should I be held liable? But that is possible. Under 1314, when a third person interferes with a contract, this is interference by a third person. But take note, a requirement, a very important requirement for this provision to apply is there must be malice in the interference. It should have been malicious. In this case, Francis Albert, a citizen and resident of New Jersey, USA, under whose law he was still a minor, being only 20 years of age, was hired by ABC Corporation Manila to serve for 2 years as its chief computer programmer. But after serving for only 4 months, he resigned to join XYZ Corporation, which enticed him by offering more advantageous terms. His first employer sues him in Manila for damages arising from the breach of his contract of employment. He sets up his minority as a defense, asks for annulment of the contract on that ground. The plaintiff disputes this by alleging that since the contract was executed in the Philippines, under whose law the age of majority is 18, he was no longer a minor. One of the questions was, suppose XYZ Corporation is impleaded as co-defendant. What would be the basis of its liability? XYZ Corporation is the third person in relation to the contract entered into between ABC and Francis Albert. Now, why should XYZ Corporation be held liable? Again, he may be held liable under 1314 if it can be proven that indeed he maliciously induced a party to a contract to violate the contract. Under the facts, the question, if any, the answer is, the basis again would be 1314, interference by a third person. Why? Because of the phrase, I would say, which XYZ Corporation enticed him by offering more advantageous terms. In other words, for a liability to arise under 1314, the first requirement, of course, is that person who may be held liable must have knowledge of the existence of the contract. From the facts of the case, dapat tingnan nyo yon. Because if he has no knowledge, how could he maliciously induce the party to violate the contract? If he merely asked the person, "Uy, you join our company," apparently there would be no such malice, okay? But I would agree that there was malice under the facts, okay? Because XYZ Corporation enticed him by offering more advantageous terms, okay? Sometimes a bar exam, the connotations of words or phrases may matter. Ang entice, I would consider medyo may negative connotation, di ba? Entice in Tagalog would be parang inakit mo, di ba? Talagang malicious. Inakit mo yung tao. At saka more advantageous terms, parang the premise is they knew the terms and conditions of the other contract, but they offered more advantageous terms. To that extent, I can also agree that the XYZ Corporation may be held liable under 1314. Now, a question here under this provision is who may be held liable? Ang common na sagot is under 1314 is the third person. Of course not. Not only the third person, but the party himself also who violated the contract can be held liable by the other contracting party. In fact, what's the nature of the liability of the party and the third person? The Supreme Court would say they would be solidarily liable. Is there a basis to this? On its face, there is no law. Nothing in 1314 which would provide for solidary liability. But the Supreme Court would consider this act as a tortious act as against the other contracting parties. And therefore, under 2194, 2 or more persons who are held liable under quasi-delict would be held solidarily liable. They would be considered as joint tortfeasors. Now, one final question here would pertain to, may the liability, however, of the third person, assuming he maliciously induced a party to a contract to violate his contract, be more than the liability of the party himself who violated the contract? The Supreme Court said in one case, hindi naman. His liability cannot exceed the liability of the party who himself violated the contract. Probably one other. Roland, a basketball star, was under contract for 1 year to play for, I suppose it's play for pay, exclusively for Lady Love. However, even before the basketball season could open, he was offered a more attractive pay plus fringe benefits by Sweet Taste. Roland accepted the offer and transferred to Sweet Taste. Lady Love sues Roland and Sweet Taste for breach of contract. Defendants claim that the restriction to play for Lady Love alone is void, hence unenforceable, as it constitutes an undue interference with the right of Roland to enter into contracts and the impairment of his freedom to play and enjoy basketball. Can Roland be bound by the contract he entered into with Lady Love, or can he disregard the same? Is he liable at all? How about Sweet Taste? Is it liable to Lady Love? To the first, can Roland be bound? Of course, even if you just cite the obligatory force of contracts, contracts shall have the force of law between the contracting parties and therefore should be complied with in good faith. And if there is a breach, of course, he can be held liable for damages that may be suffered by the other party. How about Sweet Taste? Is it liable? I would also agree that Sweet Taste may be held liable under 1314. Apparently, from the fact he was offered a more attractive pay plus fringe benefits, and considering the Supreme Court sometimes would use this doctrine of common knowledge. Okay, as a basketball team, it should be aware as to who are the players of the other teams, di ba? And therefore, it cannot feign ignorance na, ay, hindi ko alam na si Roland pala ay a player of Lady Love. So, because of the knowledge of the existence of the contract between Roland and Lady Love, and in fact, Sweet Taste offered more attractive fringe benefits, it would appear that it maliciously induced Roland to violate his contract with Lady Love, and therefore liable under 1314. And finally, the last one would pertain to a stipulation for attrui. Okay? Let's start with the nature of this concept. This is merely a stipulation. Literally, stipulation in favor of a third person. And therefore, the benefit in favor of a third person must not be the principal purpose of the contract. There must be a principal purpose. The benefit in favor of a third person must only be incidental. Example, if A and B had an agreement that each one of them will contribute like 1 million each, for the entire amount, 2 million, to be given to C, a third person, on installment basis, maybe on a monthly basis, like 50,000 a month. The benefit in favor of C, which is 50,000 a month, is that a stipulation for attrui? The answer is no. Because clearly, the agreement of A and B practically is the benefit in favor of C. That is the main purpose of their agreement. That is not merely an incidental benefit. A better scenario where the benefit would be incidental probably would be a contract of loan. There is a contract of loan between A and B. However, it was stipulated that as to the interest that would have to be paid by A to B. Example, they agreed that the interest rate would be, let's say na lang, 12% per annum. Instead of the interest that will accrue on a monthly basis, instead of A giving such amount to B, that amount will be given to a third person. This time, it is a stipulation for attrui as long as there is no burden, there is no condition imposed upon the third person, there is no compensation to be paid by the third person in relation to the benefit. Because kung nakalagay sa stipulation that C will have to render service to B, ay that is not a stipulation for attrui. That would not fall under this provision. Again, gratuitous benefit ito. Walang kapalit. Bait lang. But, take note, another requirement in order for that benefit in favor of third person to be considered a stipulation for attrui, which would have other requirements therefore for that person to be entitled, is that there must have been a clear and deliberate grant of this benefit. The grant must not be only incidental. If you read this case of Bonifacio Brothers versus Mora, ang Bonifacio Brothers, ito yung parang car repair shop. Mayroon pa yatang natitira na car repair na Bonifacio Brothers ang pangalan. Anyway, in this case, a car was brought to one of the shops of Bonifacio Brothers for repair. Incidentally, that car was the subject matter of an insurance contract. In the insurance contract, there was a stipulation that for the beneficiary to be able to receive, to be entitled to the benefit under the contract, the car must be brought to a car repair shop for repair. Pursuant to that provision, dinala nga ang kotse sa Bonifacio Brothers. Now, in relation to the proceeds ng insurance contract, sabi ng Bonifacio Brothers, we are the ones entitled to the proceeds ng insurance policy because that provision in the insurance contract is a stipulation for attrui. Sabi ng Supreme Court, hindi, because there was no clear and deliberate grant of benefit in favor of Bonifacio Brothers. Incidental lang under the contract na dadalhin sa isang car repair shop. Okay? There was no really a clear and deliberate grant to Bonifacio Brothers, so this is not a stipulation for attrui. Now, if that stipulation is indeed a stipulation for attrui, for the beneficiary to be entitled to this benefit, finally the law requires that the beneficiary must communicate his acceptance to the obligor. Not even to both parties, but only to the obligor before its revocation. As I discussed a while ago already, in order for the beneficiary to lose such benefit by virtue of a revocation, the revocation must have been agreed upon by both parties. As discussed, for example, in the case of Kaufman versus P&B, if only one of the parties would revoke the benefit, that will not be a valid revocation. Otherwise, that would violate the mutuality of contracts principle. Okay? So, I think that should be enough for as far as the fundamental principles. I think wala na.